So we are here for oral argument in the Bank of New York Mellon versus Nicholas and Amy Nutter and Shale Creek Master Association. Of course, for purposes of today's oral arguments, the parties are Nicholas and Amy Nutter and Shale Creek Master Association. Each party will have 15 minutes to present its arguments. The appellant may reserve up to 5 minutes for rebuttal. If you wish to do that and plan to reserve time when you begin your argument, let me know, and I will do my best to keep you apprised of how much time you have. I'll be keeping track of the time. The arguments are being visually and audibly recorded. They will be posted on YouTube when this is over with. I'm trying to get the timer set here. I think that's about all I have to say. We have read your briefs and we are ready to begin when you are. All right, Mr. Nevin, you're the appellant here, so whenever you're ready.
Okay. Thank you, Your Honor. Good morning, and may it please the court. As appellant, I would like to reserve a full 5 minutes for rebuttal.
All right.
I want to begin by thanking the court for the honor of its time, along with the time of appellee's counsel in helping present the issues to the panel in a considered manner. This is an issue that I believe will have a significant impact in the area of community association law, where so many of these associations already exist, and it continues to be the dominant form of residential development within the state. From a legal standpoint, the court can appreciate the value of predictability and can understand the challenges of practicality in the face of a high volume of similar cases or issues that come before it. Practicality and predictability will form a theme of my argument today. The bulk of my argument will observe the need for predictability in applying or not applying Chapter 5312 and its discrete provisions. From there, I will allocate time to observing the practical need to make the focus on business record authentication and inquiry into familiarity with the record itself, and not personal knowledge as existed at the time of its adoption or creation. And finally, I will conclude by highlighting the practical need for practitioners to supplement the record before the court and to have the issues tried before the court against the controlling law and the controlling provisions as applies to this case against Section 5312.12 of the Ohio Revised Code. This is a matter that in many ways should have been very simple. It was a foreclosure action initiated by Bank of New York Mellon, and it is actually the third foreclosure action that originated by the Bank of New York Mellon against the owners in this case. Since 2010 forward, there have been 4 liens filed by Shale Creek Master, the appellant in this case, to address issues with the Nutter's account. In this case, the association joined the action on the heels of a separate municipal court case where a judgment was obtained against the Nutters or by consent of Nicholas Nutter because there was an existing arrearage. There was no dispute to that fact, and there is no dispute that there are subsisting liens of record. And those liens of record must be reviewed in relation to 2 sources of authority. The first being Section 5312.12 and the association's governing documents. And in light of these circumstances, it is critical for the court to observe that, yes, there are assessments at issue. There were assessments at issue when the 2013 lien was filed. There were assessments at issue when the 2016 lien was filed. Those liens remain subsisting, and pursuant to the statutory language and pursuant to Shale Creek's governing documents, they are continuing liens. And the statutory language is clear. These type of liens are continuing liens. Once in place, they are subject to automatic subsequent adjustments, reflecting additional unpaid interest, late fees, enforcement assessments, collection costs, attorney's fees, paralegal fees, and court costs. This is something where the liens were in place. The preliminary judicial report put all the parties to this action on notice that the liens were in place. Mr. Nutter's consent judgment confirms that he was on notice that the account was delinquent, that the association had taken collection action. And this was something that the association thought was going to be addressed. The action was filed in the spring. It was March, April 2018. And the matter proceeded, and the docket reflects that there were several telephone conferences. And the association tried to work with the Nutters, but could not obtain any cooperation. And that's demonstrated by the fact that the liens remained in place, and there were no efforts to have them removed. So eventually, yes,
Counsel, could I ask you a question? When you filed the initial municipal court action against the Nutters, did you plead in that complaint for interest as well as attorney fees in prosecuting that action?
Yeah, so the way that the municipal court case would have proceeded is in light of the unique relationship that exists. For small claims complaints, where the association is pursuing a money judgment, there is a flat fee that the association was billed. That is something that was demonstrated on the statement of account that was provided. And again, that's another issue that it's essential for the court to note. Mr. Nutter should not have been surprised by the charges. There was a complete itemized statement of account dating back to 2015 attached to the association's pleading in this case.
Counsel, could I stop you just for a second?
Yes,
because I lose track of things easily anymore. Or maybe I did it all my life. And the question I asked you was, did you plead and request interest and attorney fees in your original municipal court action?
Not in addition to those incurred for the filing of the complaint. For purposes of the small claims action, it would have been the attorney's fees incurred to date, which included a collection letter and the $550 for the filing of the municipal court complaint.
Okay, so go ahead.
So subsequent to that, I noticed that was there ever the notice requirements for 53-12-11, were ever provided to Mr. Nutter notice requirements for the $70 and the $30 subsequent to the payment of everything?
At that point in time, Mr. Nutter, the foreclosure case had commenced. If I'm understanding the question correctly, it's in relation to the filing of the satisfaction of judgment and those associated
$100, yeah.
Yeah, and those charges accrued after the foreclosure action was commenced, and it was something that, no, there was not a 53-12.11 notice provided, but the 53-12.11 notice does not apply when there is a subsisting lien in place. And when the association was continuing to try to address that issue, that's something that the declaration explicitly indicates that the association has three qualitatively distinct types of assessments, and it's a matter of tracking the language contained within section 7.13 of the declaration. And that section says the master association shall have a lien under three circumstances for any assessment levied. Okay, so those are the assessments that are either regular assessments or special assessments. The next four is for fines imposed. Fines are often analogous or analogized to enforcement costs or enforcement assessments. This was neither. This falls under the third four, for interest, costs, and reasonable attorney's fees. And when you have multiple subsisting liens of record, you have a 2013 lien, you have a 2016 lien, you are trying to work with the owner in having those liens removed, because there is the practical component. As a practitioner, if those liens remain in place, you are going to be contacted by title companies to have them removed in the event that an owner is trying to refinance. You are going to expose the association and potentially your law firm to additional risk in the event those liens are not timely removed. So when you are engaging in the practical back and forth that happens after you have caught the owner's attention, after they have taken the initial steps to address the arrearage, you do not continue, at least as I read the statute and as the declaration suggests, you do not continue to provide extra statutory notices, extra technical notices. Those would be appropriate in the first instance, yes, but this is not that case. This is a case where there were multiple prior subsisting liens of record, where in a municipal court case, the docket clearly reflects that Mr. Nutter consented to and acknowledged the delinquency. And yes, he took steps to address it, but those steps were never completed. And that's the issue. We're dealing with the third type of authorized charges under section 7.13, and those are not subject to additional notice. That's what the Inree Tyrell court reviewed, and those are the same types of charges that the Sparks case reviewed. These are afforded to the association under the documents, and I think that revised code 5312.12 is very clear in that regard. To require a 5312.11 technical notice under these circumstances completely edits the subject to subsequent automatic adjustments language out of the statute. It no longer has application then. Okay, a continuing lien does not qualitatively remain a continuing lien if you have to continue providing these technical notice requirements and providing opportunities for a hearing and opportunities for cures that do not apply under the circumstances. The liens are there. Everyone knows the liens are there. And
Mr. Nevin, I'm going to pause you for a minute just because you are into your rebuttal time now. You're welcome to continue, but I just want to let you know.
Okay, Your Honor, and thank you for that notice. I would just observe that the notice wasn't the issue as far as the subsisting liens were there, and at that point it becomes an issue where the owner needs to remain accountable, and association counsel needs to have a predictable application of the statutory language and the declaration where the owner is forced to bring a discharge of lien action consistent with 5312.12D. That's the only point where the trial court is vested with equitable powers.
Okay, well, since you just said what you said, let's just say, for purposes of argument here, that you are correct on every point you're making. Your remedy is what?
For this court to determine that there is a valid.
No, what was your remedy request at the trial court?
For foreclosure of the lien. So I'm asking that this court.
And how does that work with equity then? Because you do concede that equity is a consideration in foreclosure, correct?
As a general matter, no. And that's something that's demonstrated by this court's decision in Brandywine, where the community association was permitted to foreclose on a lot that had demonstratively negative equity. There was no value left in that property, and this court sanctioned the foreclosure in that case because it followed the statute.
But was equity really even? I'm sorry.
They are to remain accountable by foreclosing their property. Is that then the moral of the story?
Yes, Your Honor, and that's actually something, it may sound harsh in a vacuum, but a lot of the documents will actually indicate that continued breaches of the declaration, think for nuisance violations or disturbing the quiet use and enjoyment of the premises, those violations alone, even in the absence of a debt, in many documents can form the basis for a forced judicial sale. Okay, this is something that beyond that, the association filed its liens, recorded multiple certificates of lien, and was never put on notice that the owner appropriately disputed them consistent with the statutory requirements or that was required by the declaration.
Judge Carr, did you have something? I'm sorry.
No, it's fine. Thank you.
All right. Mr. Ratcliffe, whenever you're ready.
Thank you, Your Honor. May it please the court, I'm attorney Rocky Ratliff. I represent the appellees, Nicholas and Amy Nutter. The Nutters bought their property on Stillwater Drive there in Medina in approximately 2007. They built a house on that lot. They continued to reside there as their primary residence since 2007. In the course of ownership, I know appellant's counsel had talked about 4 liens. I think 3 liens were in front of the trial court. And page 63 of the trial transcript, I think he basically said he's presenting the lien from 2013 and the lien from 2016 to the court in context. In fact, appellant's counsel told the court that the lien from 2013 and the lien from 2016 was satisfied. So he presents trial exhibits 4A, 4B, and 4C, telling the court that 4A and 4B were satisfied, that basically we were there on lien 4C, trial exhibit 4C. The defendant or the appellees at the time had presented trial exhibit D, which was the lawsuit that was filed in Medina as to exhibit 4B. And then we also presented the trial exhibit E, which was filed November 14, 2017 in the Medina Municipal Court. That was a magistrate's decision. It was a judgment entry where the plaintiff, Shale Creek Master Association, with opposing counsel present, and Mr. Nutter had agreed that he owed $2,209 plus 4% interest plus court costs. That's it, court costs and that amount. And Mr. Nutter was to make $500 a month in payments towards that amount, which Mr. Nutter did. He made $250 payments twice a month until it was paid off. They also agreed that the plaintiffs would not try to exercise any type of or execute the judgment in this case as long as Mr. Nutter was making those payments. Mr. Nutter made those payments. In fact, testimony said he tried to make them so that Shale Creek could take them directly out of his bank account, but he couldn't do it until it reached a zero balance. So he made those payments all the way until, I believe, April 23rd, he had a zero balance, as their recording in Trial Exhibit 5 shows their ledger, so to speak. In April of 18, that's when the Bank of New York Mellon filed their breach of promissory note foreclosure action against the Nutters. April 23rd is when it was paid off and had the zero balance with Shale Creek. And then starting May 1st, all the payments from the Nutters accounts for assessments were taken directly out of their account. So Shale Creek is pulling the $53 every time they want. They're pulling the $250 general assessment fee at the beginning of each year every time out of the Nutters account. Interestingly, sometime, I think it's Exhibit F, Trial Exhibit F, there's a notice of satisfaction of judgment filed May 21st, 2018, where Shale Creek tells the whole world that the Nutters have satisfied this judgment. Then all of a sudden, they charge him for that. Even though they agreed he's not paying attorney fees, they're going to charge him. Now, that's when it starts getting a little rough, apparently, for the accounting, because they're getting all their assessment money, but now they're charging him attorney fees for them to be present in his foreclosure action, which he got no notice that he's paying Shale Creek to be there. Their actual covenants don't address him paying legal fees for showing up in some foreclosure action. And the law doesn't say, hey, we're necessarily going to do that. So he's getting no notice whatsoever that Shale Creek's there. He doesn't understand that Shale Creek is charging him to actually be there. Then around November of 2018, they put a lien on his property and give no notice whatsoever per their covenants or per the statute that they're doing such. And when they put that lien on there, then they change their complaints and have a cross claim now against Mr. Nutter, saying that we want, they actually are asking for the $1,814.80 for past assessments, and now they want to recover attorney fees. Well, Mr. Nutter has been paying the assessment, so he has no idea what they're even talking about. And as previously stated, they did no requirements as far as notice that he has been paying attorney fees for this amount of time. So when we go to trial, the court eventually finds in the Nutter's favor, but how they find it is, I think, rather important, because they find that they did not comply with any of the notice requirements. And in fact, while we're in court, we're actually paying, Mr. Nutter is supposedly paying for Shale Creek. Interesting enough, if you look at Trial Exhibit 5, they're paying Shale Creek to bring actions against him. They're paying, he supposedly got to pay for the cross claim that's being brought against him to Shale Creek. So we think, as far as these liens, that Shale Creek has been putting liens on people, they keep them on there. And if they do not get removed, Shale Creek then comes back in and says, well, we had a lien, so we're going to start charging you now attorney fees. That's what they're doing in this case. But the attorney fees they're charging has nothing to do with the lien that was actually put in place. So he keeps talking about a 2016 lien that still might be on the property, but the actual amount of why they put the lien on has been satisfied. And he keeps wanting to bring this up. It's like having a mortgage on a property. The bank can't come in and foreclose on the property on the mortgage if the mortgage has been satisfied. The liens have been satisfied. He is asking for attorney fees for Shale Creek to participate in a foreclosure action. And their participation is simply to say, hey guys, we have a property interest here. That's it. They did nothing else. And then at the end of the action, they came in and said, Mr. Nutter, now you have to pay Shale Creek, the association, because we actually did stuff in this case to actually show that we had a property interest. And they're asking for him to pay for all of that.
Counsel?
Yes.
Counsel, the HOA is actually arguing that the Nutters had a responsibility to have the liens removed. What's your response to that?
I think the Nutters can have a lien. I think the Nutters, Your Honor, ultimately can have the lien removed, or by operation of law, it drops off after 5 years where it can't be enforced. My response to that is, if it's satisfied, but yet a piece of paper is just filed at the recorder's office, it doesn't mean it's really valid. It's a lien because it hasn't been removed, so it might cloud a title, but they can't execute any kind of judgment against that lien. Every time that Mr. Nutter went to court on the Shale Creek case, he agreed. Counsel for appellate says that it's completely satisfied, represents to the common pleas court is completely satisfied, files a judgment with the court saying it's completely satisfied. But his position is, because it's still out there at the recorder's office, that at any time that Shale Creek wants, they can now add to attorney fees or interest or something to put, it back to the Nutters that they have to pay, which is ludicrous. It's not what the law allows for, and it is in violation for what he is asking for. There's nothing in his covenants that says he can do it, nor is there nothing in the law. And actually, Your Honor, when you talk about 5312.12, which is D, it says the owner may commence an action. It doesn't say the owner has to. And in fact, in this case, Shale Creek commenced the action. So once we get to the action and they lose, now they've appealed because they're saying we got a lien and we should have done that. I think the court was proper on saying in their decision that it doesn't matter 531211 is improper if the charges are improper. It's irrelevant what the statute is if you don't have proper charges and you haven't followed the notice procedure. That's where the court went with this, and I think it's totally the correct decision. But Shale Creek believes just because they have liens that haven't been totally removed by a piece of paper, they can keep executing liens and charges and assessments, even though those charges, liens, assessments, attorney fees, whatever you want to call it, has nothing to do with the reason the lien was put on there in the first place. Because they're trying to execute on attorney fees for a foreclosure action on a 2016 lien and a 2018 lien that they just slapped on there. I mean, it's pretty clear what they're doing. They're just slapping liens on people. And when we're in a foreclosure action already, you have to ask yourself, why would Shale Creek go out and slap a lien on if they're participating already in a foreclosure action? All they had to do was amend their complaint at that time saying you owe us attorney fees. The problem is they know they want that extra little that little extra on top of the court. They say court we, well, they were at that lien, and then they used it to amend their pleadings. That's all they did. I think the trial court properly told Shale Creek what they could have done. They could have negotiated additional fees in the 2016 lien at the Medina Municipal Court. None of this would have happened then because their accounting would have never had Mr. Nutter behind, except they still would have wanted their attorney fees, so they had to figure that out. So they slap on the 2018 lien. And then they also tell them, if you want property owners to pay you to be in foreclosure actions, individual lot people to be there to assert the overall association's position, then you need to amend your covenants. That's what needs to happen. Nowhere in their covenants does it say what happens in a foreclosure. And that is what we have here. I think in equity, it obviously matters in a foreclosure action as to equity. I think in this case, the most the court could see the Nutters possibly owing was $100 and thought it was inequitable to be basically trying to take someone's house. I think courts, and especially common pleas courts, should always be looking at matters with equity and anything. And I think in this case they did. And I think it's page 21 of their decision, the judge said, Judge Collier basically said, he pointed out that Shale Creek sued and obtained a judgment. The Nutters satisfied the judgment. Shale Creek received every penny, and this is exactly how the system works, and it's how it's supposed to work. And for them to try to change some system to make the homeowners associations actually have lien powers that are above common pleas of municipal courts when they go in and agree to those agreements are just preposterous. They're asking the court to give them unlimited authority to put a lien, and even though they have judgments or they agree to judgments, that they can keep exercising and putting attorney fees on homeowners when they want. So on behalf of the Nutters, Your Honor, I thank the court for allowing us to present our position here today, and I thank you. Thank you.
All right. Mr. Nevin, I'm going to have you hang on for a second. Judge Carr, you okay? You with us?
Yeah, I am.
Okay.
Thank you.
All right. All right, Mr. Nevin, you can proceed. You have about 1:40.
Okay,
Okay,
thank you.
You can go ahead.
Thank you, Your Honor. Thanks. Enforcing liens is an emotional topic, and court precedent indicates that equity follows the law, and that's what needs to control here. The Nutters had a remedy. That remedy was to initiate a discharge of lien action and to put the association on notice that these charges were in fact in dispute. And the whole world was on notice once the preliminary judicial report was filed, once the documents were filed with the recorder's office, that the liens were in place. And to look back, the problem is this does not offer the association finality. Those liens still cloud the property's title. The relief that's described in 5312.12D says that, again, it's in an action to discharge lien if it's determined that the unpaid amount of the assessment or charge was improperly charged to the owner or lot. The court shall enter an order that it determines to be just, which may provide for a discharge of record of all or a portion of the lien and an award of attorney fees to the owner as appropriate. And that is something, the attorney's fees are available under statute, under a declaration. Section 7.13 clearly indicates that the association is entitled to perfect its liens, is entitled to foreclose on its liens, and to be reimbursed in the process, so that the owners of delinquent accounts are held accountable for their failure to timely pay assessments to the association. And that's the predictability that is necessary to these associations. They are not-for-profit associations run by volunteers. And when you have owners who continually fail to meet their obligations to the association, there has to be some remedy and some finality. There is no finality here, as there are multiple liens.
Counsel, you don't have long, but I just have to ask you this question. You keep speaking of finality. How do you ever have finality if you can just keep tacking on attorney fees? Because right now you've incurred additional attorney fees, so now there's a different amount. And I think the trial court said at some point this has to end.
Yes, and just so you know, your time is up, but it was up before Judge Carr asked the question, so please go ahead and answer her question.
Okay, Your Honor, to answer your question, the finality comes in the finding of a valid or invalid lien. And if it's valid, the lien is able to be foreclosed upon as a statutory right. If it's invalid, there needs to be an express indication that it's invalidated and it needs to be erased from the county records. There needs to be finality, and that's what the association was asking for. Thank you, Your Honors.
All right, gentlemen, thank you both for your arguments. We will take the matter under advisement, issue a written decision in due course. One thing I do want to point out, you may have noticed we lost Judge Schaefer along the way, not in spirit, and she will be, oh,
there she is.
Wow, impeccable timing. She will be watching this argument. We lost her partway through your argument, Mr. Ratcliffe, so she will have the ability to go back, and she will be watching the entire argument then before we conference, and so she will have gotten to hear everything that you had to say, and then again what you had to say for your rebuttal, Mr. Nevin. And you will both be given copies of our written decision when that comes about. It'll also be posted on our website and on that of the Supreme Court. Again, I thank you.